The 14A District Court for County of Washtenaw, State of Michigan is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
All right. Court does call the case of the People State of Michigan versus Justin Phillips. Counsel, state your appearances, please.
Caitlin Kirby on behalf of the people.
Erica Julian appearing on behalf of Mr. Phillips.
All right. And what are we dealing with today?
Your Honor, today is the PCC as well as a special time for some motions regarding Mr. Phillips' motions that were previously filed. And I forwarded the response by Ms. Kirby to Mr. Phillips, and I believe those will be argued today. I additionally filed a motion regarding his bond conditions as well as a motion regarding a production of a transcript. It's my understanding that the motion for the production of a transcript to indigent defendant is no longer necessary, that Mr. Phillips had already paid a check and covered those funds to receive a transcript. So it would just for me.
My understanding is that it's not been paid in full, however.
If it was a deposit for
there was a
$50.
deposit placed, but that there is a balance that is owed.
Yes, Your Honor, there's a balance of like $25 and some change. I did get the email yesterday from Mrs. Ann Wildling, and she'll have the balance by tomorrow morning.
That would make that move in any event. All right, what's the next motion?
Your Honor, I would, if I can speak on the motion to modify bond conditions, otherwise I'm going to be requesting to adjourn the PCC outside of Mr. Phillips' motions. The bond conditions do involve Mr. Phillips' regular travel that he always had previously regarding his business activities, as well as his medical activities. Since filing this motion, he had sent to me another email indicating more travel requests, including to Washington, D.C., as well as to Houston, Texas, regarding another consulting appointment. So I would ask to modify the condition for travel. If he would be permitted to have continental travel, it would help me to not have to request to take up the court's time requesting for each individual time every time. I don't believe that Mr. Phillips is a flight risk or a threat to the community. He's very invested in this case, as the court, I think, believes, or at least would be evident to the court through all of his communications. And so I would request to modify that to continental. Otherwise, he has stated previously that he's not an alcohol or drug user. He's never had a positive test, that is not an issue in the case, and he would ask to be released from that condition of his bond.
Response from the people.
Your Honor, I would leave that in the court's discretion. I believe the reason why Ms. Julian had filed that motion is because we, as the court stated last time, we have filed a lot of stipulation and orders for him to travel. And before I sign those, I need proof of the appointments. So when Ms. Julian asked me just for a blank all travel, I asked her to ask the court because I was not comfortable doing so, given the fact that some of the stipulations and orders that I've signed were out of country. So I don't know what the reasoning behind these appointments is. I don't need to know the reasoning behind these appointments, but I wanted to see proof of the actual appointments before I would be stipulating to them. So I would leave it in your discretion as to what you want to do.
Well, and the court feels the same way. While I don't like all of these motions coming forth, I'm going to deny the request to giving just continental travel within the United States. I mean, he has to have a purpose when he leaves the state of Michigan, and certainly with that purpose, the court will grant it. It also has to have specifications as to potentially what the defendant is doing, as well as the time frame for the defendant's travel. So if we have to do it stipulation by stipulation, we'll have to do it stipulation by stipulation. But I'm going to deny that request. The second part of that request was regarding the drug testing. The court is, certainly I understand somewhat the nature of the case, or at least the court to the extent it does. I'm also going to deny that request. His bond conditions will remain as they are and will fluctuate. If he has travel, he has travel, and we'll deal with that. But in terms of the testing, that testing will continue.
Yes, Your Honor. I appreciate the court's ruling. As for one of these requests to travel, it is from September 2nd to September 7th, and tomorrow would be September 2nd. And Mr. Phillips, you indicated that was for consulting travel. Can you express to the judge exactly why you need to leave the state from the 2nd to the 7th so we can seek to get permission today?
Oh, well, that was for a family reunion, actually, Mrs. Julian. And additional to that, there will be other additional consulting business in that area, as well as appointments to interact with the Department of Justice, as well as the FBI, in regards to my civil rights violations that have been presented in this matter and surrounding this matter.
I guess what I'm concerned about is why that isn't being done by stipulation of the parties, much like before, where things are presented, and because that's a lot of things that the defendant just rattled off there. And I don't have any proof whatsoever of any of that. I mean, for example, do you have an appointment with the DOJ?
I do not, Your Honor.
Okay, so why would I be permitting travel for an appointment that doesn't exist?
Oh, well, I was actually going, which was scheduled with my brothers. It's a family reunion. So while I was there, per the time of the ticket time, I was going to handle my other business in regards to this matter, as well as consulting with area friends that I have.
Here's how we're going to do this, because that was a word salad, quite frankly. If he's going for the purpose of the reunion, then show proof of that it's family reunion going on, and that seems to me to be stipulated to in terms of where he's going and the time frame of the travel. And certainly, as these orders have been stipulated to in the past, that can be done. So I'm not going to rule on that. I'm going to rule on what's before me right now, which is the motion to travel, the carte blanche motion to travel, which I'm denying. But that doesn't mean I'm denying individual trips where there's satisfactory proof of those.
Thank you, Your Honor. I will be in touch with Ms. Kirby about that by tomorrow morning. Thank you.
All right.
And Ms. Julian, just for the record, I am off for the next 5 days. So if you would like to email me before end of day, I will respond.
I will absolutely do that. Thank you.
So that takes care of what is the other motions that need to be, because I have motions that apparently that have been filed by counsel and motions that have been filed by the defendant himself.
Your Honor, when we were here previously, approximately, was it 4 weeks ago at this time? I believe it was August 4th. Mr. Phillips had filed a motion for change of venue, as well as, I believe, well, at least that's part of the title of it. And that may be a two-part motion, that he had done that on his own. At that time, I had indicated to the court that I had not filed that, and I do not argue motions that I do not file. And obviously it would be in the court's discretion whether or not to hear Mr. Phillips' motions as he had filed them on his own, and that gave Ms. Kirby a deadline as of last Thursday to submit a response. She submitted that well in advance of that deadline. I forwarded it to Mr. Phillips, and it's my understanding that that motion remains pending before the court today. And
the motion for the change of venue?
That was my understanding of what Your Honor had stated last time.
Right. I've reviewed the motion for change of venue response to that. I'm ready to rule on it unless there's additional argument.
Nothing from the people, Your Honor.
Your Honor, I have additional argument for it.
Go ahead.
Okay, Your Honor, to prevent the further presence of any type of impropriety in this matter, in any matter surrounding this matter.
Well, let me stop you there, Mr. Phillips.
Okay.
You show no impropriety in this matter. You show no prejudice by having this matter here. I think also your motion for change of venue is very much premature with regard to any prejudice you may believe has been caused. But go ahead with your motion, because I mean, you have to back up. You can't just give me things without some backup as to specifically what they are and whether or not they are legally cognizable as some type of impropriety.
Your Honor, my civil rights are being violated over and over again. Due process in regards to this case, in regards to the sheriff's department, in regards to the prosecutor, Ms. Kirby, making statements that are not true to fact. I'm a knower of fact. I have a lot of information that has not been presented on pretrials with pretrial motions with Ms. Julian, with all this time that has lapsed in regards to this case. There is a presence of impropriety for a lot of reasons. There's police misconduct, acting under the color of law. I had the first attorneys and then Ms. Julian. It's the same conduct, deja vu, in regards to essentially dragging their feet to represent, to investigate. In regards to change of venue, again, the county corruption that I've found where there's illegal statements, false statements being made against me in regards to, oh, you provided a receipt to the FOIA director, et cetera, of $30-something. That's not true. And that's an attempt to character assassinate. That's an attempt to undermine and totally disrespect. My civil rights are violated because I did not get the due process that I deserved and that all citizens should. In regards to all of such,
Mr. Phillips, let me
go ahead.
Stop. Thank you. Let me just stop you. You throw these words out without any backing. It is fine for somebody to say that my due process rights are violated. If that is indeed true, and even in the motions, I have no factual basis to even begin to make the determination. You say that your civil rights are violated. There is no factual basis. First of all, I'm not even sure under what statute you're claiming your civil rights were violated because you don't lay it out. You also don't lay out any factual basis upon which this court could make a determination that your civil rights were violated. These are nothing more, as I'm listening to you, than your conclusions about something, which is insufficient to sustain any motion for this court regarding any relief that you're requesting. I don't mind listening to somebody, but you can't just throw out these conclusions that there's been some violation or something without some factual basis to it.
Well, maybe Ms. Julian can speak to the fact that she had informed me that this case is civil in nature, that I should not have been charged. What I found is this case involves, it's really civil in nature. The entities involved engaged in fraud in the factum, fraud in the inducement. This is breach of contract. All that is contract in regards to what transpired. The color of law where the police engaged in is due process violations. They did not investigate this matter in totality. The report will say it in further perspective. Evidence will come in and show such. It's very clear. I should not have to act as my own attorney because Julian was assigned or is assigned, as well as the other individuals, Delphia Simpson or Ronald Brown through Delphia Simpson, were my attorneys. And, we've all had these conversations off the record, but then when it gets on the record, nothing's being said, nothing's being done. It's a redundancy in regards to any and all information that needs to be presented in this matter through the pretrial process. And because it's not happening, yes, it is a presentation of impropriety on all levels in regards to all what's going on.
Mr.
It is what it is.
Mr. Phillips, that whole statement that you made to me is simply full of non sequiturs that make no sense. I mean, you did not use, you used the word color of law, but it was not used in any proper context that this court can even grasp. I don't mind listening to you. I don't mind hearing what you have to say. But the sentences that you're giving me, I can't even begin to try to put together.
Okay, Your Honor. Okay. Oh, sorry. Let me stop this. Okay, sorry, Your Honor. Your Honor, I'm telling the truth. I'm trying to tell you, I'm not a lawyer. I can do the research. I'll do it. That's fine. I know what it is. I know what I'm talking about. I'm not just pulling out words. I'm not, this is very serious.
Mr. Phillips, I'm not saying that for you and for everybody else, that this is not serious. I am not saying even that what you're attempting to try to tell me might have some merit. I don't know that. Because what you're saying to, and I realize you're not a lawyer, I realize that you're grasping onto phrases without context to them. And I can't even, anybody that's practiced before me knows if people appear before me, they don't have to say it exactly right. I can get what somebody is saying, but as I'm listening to you, I can't even get there. You're just throwing phrases out at me unconnected.
Okay.
I mean, I don't, one can suspect certain things are going on. People can come to different conclusions about it or whatever. But with reference to the change of venue in this case, I don't see a basis upon which I would change venue.
I mean, I really don't, I don't know what else to say. I wrote it. It's the truth. It's fact. There probably is not enough law to back it, but it's very true what's going on. And someone where, in myself, the
Oh,
defendant
sir.
is,
Mr. Phillips, you have said the first thing that has made sense to me. And that is that there's not enough law to back it. I rule by law. I don't rule by people's feelings. I don't even rule by my feelings. And you yourself now are admitting that there is not law to back it. Finally, we can agree on something.
okay,
So for those reasons, I'm going to deny your motion for change of venue.
that's fine, Your Honor.
I don't think it's appropriate.
I would like to, I would like to motion the court to represent myself pro se.
Did you place that motion in writing before the court and the basis for that?
I did send an email over, but no, it's not on the motion like this one.
Mr. Phillips, this is where you're going to end up in trouble. Because if you're going to seek to represent yourself, things are going to have to be filed with the court in its proper form. And you're going to be held to that. So as I look at the things that you filed with the court, I don't think you know what that is. I'm not saying that you haven't gotten some information before the court, but certainly it has not been in the proper form. And what that's going to lead to, and what I want you to think about, is that's going to lead to certain issues that apparently you have not being heard by this court. Because if it doesn't come to me in the proper form and in a manner in which those that may have opposing points of view can answer it, and then the court would be in a position to review everything, the court can't hear it.
The court doesn't hear oral motions for pro se or self-defense.
I think given where this case has gone, I'd like to see your reasons for doing it. I'm not saying that I deny it. But I think, quite frankly, sir, you are making a rash decision. And what is my hesitancy? I mean, you have a right to represent yourself. You are making a rash decision that will get you nowhere. And I'm not just saying that out of the blue. The whole motion that we went through regarding the motion for change of venue is an example of that. What is very clear to me, if that motion for change of venue is what I would hear from you, is you need to think long and hard as to whether or not you want to have somebody put together what are these series of thoughts you have.
Well, it's a series of facts.
Well, you say what you want to say. You can't just continue to put forth to the court, and I've used the word time and time again, a series of non sequiturs that make no sense. And I think you need to think real carefully about that, because what's going to end up happening is that train is going to run off the rail real quick.
Your Honor, I totally understand, but Sixth Amendment rights, Fourth Amendment, all this constitutional rights, it's just a mess.
Sir, understand something. Not only have I for 30 years been dealing with the Constitution, I teach it. So don't try to give me a lecture about what you think you know. I am attempting right now to make sure that you are not making a drastic error. And I'm doing that for your protection. That is the only reason that I'm saying any of the things that I'm saying.
I do possess some law on it, Your Honor. I don't know if you want to hear it.
Sir, I understand the law and somebody representing themselves. I also understand that I'm not going to go through with you everything that I understand. I don't have to rule on that motion today. There was going to be an adjournment request, Ms. Julian, since you are still in this matter.
Yes, Your Honor. Given the amount of discovery that's been coming through for Mr. Phillips, I understand that he's charged criminally with these 2 counts, and that to the extent that he has had experiences with the sheriff department or with the prosecutors or with the court system as a overall, that has become much greater to Mr. Phillips than the criminal matter for which we're here for. And so going through my emails, I realized when I did a quick search, in the last couple of months, there have been approximately or over 200 emails associated with Mr. Phillips in my emails. And a lot of it has to do with discovery coming from different corners, as well as different thought processes and different things being sent out and then coming in, and then obviously trying to parse out what my responsibility under the criminal case is, So I'm finally to a point where I understand in my chronology and my narrative for Mr. Phillips, the pieces that I'm missing that I need to specifically get, and how to put that together for a preliminary exam. And so I'm requesting a 4-week adjournment so that I can obtain those pieces and share them with the prosecutor as necessary, as well as permit Mr. Phillips, if he wants to file any type of motion to go pro se. Obviously, while I'm on the case, I'm obligated and responsible to his case. So I was going to request 4 weeks.
Is there a response from the people?
No, Your Honor.
Sure, I'm going to do. Going to adjourn the probable cause. I'll adjourn it to October 6, 2022 at 9 a.m. It sounds like there's discovery or at least information that either needs to be either go from the defense to the prosecutor or from the prosecutor to the defense. So it'll be October 6, 2022, 9 a.m. Or as your Zoom invite indicates, if the defendant wishes to proceed in pro se, I would need something in writing indicating that that's what the defendant wishes to do by way of a motion. I don't need, if that is filed, I don't need a response from the state regarding that unless the state feels that there needs to be a response, or if Ms. Julian feels there needs to be a response, the court can handle it on its own. But it needs to be, if you file that, Mr. Phillips, it needs to be in proper form to this court. You would be
Yes, Your
bound.
Honor.
You would be bound by the same rules as any attorney, and you need to understand that this judge will hold you to that. Is there anything else, Ms.
Yes,
Kirk?
Your Honor. The last time we were here at this hearing, I brought up Mr. Phillips' presence at our office that was frequent. I asked the court if he would ask Mr. Phillips to stop coming to the office, given that he didn't have a reason to be there, and if he could call and or email. While it was not a court order, the court did tell him that he could email or call. Since then, Mr. Phillips has been to our office. The time in between, it's my understanding he was respectful, but demanding. And so that he doesn't have any cases with us. I did look last time besides this case. When I searched on the record, I could not find anything. After the court hearing, I was told that he was an alleged victim in a matter that was being reviewed. So I now looked that up, and that case was denied. So there is no need for Mr. Phillips, as his excuse was before, if he could come to the Victim Services Unit, for him to be at our office, since he is still represented by an attorney, and because there is no case where he is now the listed victim.
Mr. Phillips, what would you like to say in regard to that?
Your Honor, I object. I won't say lie again in regards to Caitlin Kirby, but I do object to what she's saying. I'm very respectful. I'm a very respectful and professional person, as stated before, and as I present. When I went to the prosecutor's office, it's only in regards to other independent matters or cases that were sent to the prosecutor's office by the respective police jurisdiction. I don't speak about this case, 22-1529 police report, or what is this, 22 F30610 FY. I don't speak about this case because I know that I have representation. I go to the prosecutor's office because, again, that's a constitutional right in regards to
No,
victims.
it is not.
Oh,
You do
okay.
not have a constitutional right to be there.
Okay. Sorry, Your Honor. Thanks for the correction. In regards to me going there, it's in regards to 22-274, an Ann Arbor Police Department case that is totally outside of this case where I am a victim, where someone used my credit card. In regards to such, that matter has been pending with the prosecutor's office since January of its reporting, and then was since July 22 of 22 for prosecution review. Another case was in regards to Isaac Small, that is a contractor in regards to this. My vehicle, I'll say, not this matter, but my vehicle, where Isaac Small is a contractor that was sent out by Liberty Mutual, who then came out, broke my grill on my Mercedes truck. I contacted the police. The police, drug their feet, did their pattern of misconduct, and then sent the matter later to the prosecutor's office. So I was informed that I could follow up with, as the victim unit, to follow up in regards to such. I was also told
you can do in writing.
Okay, so that's totally acceptable. That's fine. I don't have an issue with that. But again, Your Honor, I refute respectfully Caitlin Kirby's statement, because prior she said that I was cursing. Obviously, it's not true. I also would like an evidentiary hearing on what she stated, because I don't present aggressive.
You're not entitled to an evidentiary hearing on that.
Okay, I don't present aggressive. I don't present demanding. And again, I'm very respectful. Yesterday.
Quite frankly, I don't care. Whatever happens, happens there. It is not necessarily relevant to me, except that for whatever reason, when you're there, it causes angst, either on your side or their side. I'm not here even to decide that, because it is not relevant to the case that is in front of me. So what I am going to do as a condition of bond in this case is you're not to go to the offices of the prosecutor's office without an express invitation from that office or a department within that office to appear there. That way, if you are a victim to a crime, that unit can arrange for you to be there if they need to talk to you. All other communication with the prosecutor's office, the other issues that you bring up, can be done in writing, and they can respond or not respond, which is their right. But I'm not going to go through this case with this kind of going into the background. I've got 2 charges before me. That's what I'm going to deal with. So I'm making that a condition of your bond. You're not to go there. You can communicate. I'm not saying that you have no contact, so you can communicate in writing, but you're not to be there.
Okay, that's understood. That's understood, Your Honor. There was a additional matter before the circuit court, 22-1557, which was a PH case for a hearing against Keith Flores, the commander of the Washtenaw County Police Department, where that person has contacted me via email, and I feel harassed. I've already read the statute law 750.411A, and that person continues to contact me.
With this matter,
well, you've conflated issues, Prosecutor Caitlin Kirby. So that's why I want to bring this up, because
but this is not the
there's a lot going on.
Your Honor.
Is there a case that is pending in circuit court?
So not with our office, Your Honor, and also the case he's referring to that he came to our office about, that's an unrelated matter, that was on a PPO, and he was told by the legal assistants that we do not take the copies of those PPOs, and that would be a different matter handled by the circuit court, and it was not relevant to the cases that we had with him. And if we needed a copy, we could get it from the circuit court.
All right, very good.
Your
All right.
Honor, that's an objection. The individual there took.
It doesn't
She took the
matter.
paperwork.
Mr. Phillips, none of this matters. I've issued my ruling. You're not to go there. If you need or feel a need to communicate with that office, you can do so in writing. If you believe that for whatever reason, your presence is required at that office, you can then seek relief of this court from that order for a specific purpose and lay it out to me. But at this point, that's how we're going to have to work. I'm not having this go on in the background. Ultimately, I'm going to get to what the issues are, hear the issues, and deal with it. But otherwise, that's where we are, and that's my order. I don't need to hear anything from either side. What else, Ms. Kirby?
Just so the record is clear, because Mr. Phillips keeps calling me a liar on the record. We did take that paperwork.
Can I just say this? Ms. Kirby, you've been before me. Mr. Phillips has been before me a number of times. People can have their views of what has transpired. I do not believe, Ms. Kirby, in anything ever that you have presented to this court that you are a liar, which is why I cautioned Mr. Phillips about that before. I don't believe that necessarily everything he's saying he's lying about, or he may have his view of it. So I understand your maybe desire to correct what he's saying. For this court and for the record, I really don't need it, to be honest with you. But if you feel a need to go ahead, you may. But I don't need it.
Nope, I don't.
Your Honor, I have everything on audio, video, camera whenever I go to the prosecutor's office. So clearly I can totally refute and object what she's stating, and I can prove as a knower of fact
Why
that
do
I
I
never
care,
did that.
Mr. Phillips? Why do I care? Why do I care?
I'm sorry, Your
That's
Honor.
why you're not going there anymore. Because you're turning things into bigger things that don't need to be. I just told both of you, I don't care. And you don't seem to get the message. Ms. Kirby got the message because she didn't say anything else. You just started talking. This is going to be a long grind if you keep handling it that way before me. I'm just letting you know.
I will follow the
Anything
orders of
else
the court.
for anybody else? You understand my orders, Mr. Phillips. Anything else from anyone else?
Oh, Your Honor.
Not from
Thank
you.
you. I will
Yes,
see
Your
you
Honor.
October 6th. What, Mr. Phillips?
Oh, I thought that, did you adjourn from 8/4 to today in regards to Miss Julian withdrawing as counsel from this case?
No, I'm sorry, Your Honor. That motion was denied.
Thank
It
you.
was
That
denied.
motion was denied.
It was denied without prejudice, and I've not sought to refile anything in your matter, Mr. Phillips.
Oh,
Thank you.
interesting. Thank you.
Wow. See you in October. 14A. Stands adjourned.